So let's talk about probate. So probate is a topic that I know that you all have talked about with us several times before. You've attended workshops and things like that, but there's always something to learn, and I'm so thankful that you guys are here in the room with us. Probate is widely misunderstood, mostly because people learn, they hear about how to prepare their home and their personal belongings for their legacy. Sometimes in the wrong places. Sometimes people are still talking about things like the reading of the will, which never happens, right? But you see it on TV. And because of all of those misconceptions, a lot of people are still out there in the community not understanding how to properly plan for the future. So we're going to talk about some things today and I think even if you've heard this topic before, we're hoping to really bring some truths to the forefront for you. I'm going to bring up our panelists. So come on up here. We've got Roberto Seda with the Seda Law Firm. And these next two are going to be super fun because it's Kristen and Crystal. So it's going to be great. Kristen is with Arvest Bank and Crystal Beard with Old Republic Title. Good?
I have gotten calls for reading of the will, and I'm starting to wonder if I need to offer that or not.
Okay. Well, all right. Why don't you guys just take just a moment and tell us a little bit about yourselves?
So my name is Roberto Seda. I have Seda Law Firm here in Oklahoma City. We have 10 team members, and we've been around for quite a while, 6 years, independent, but before that I worked as an attorney since 2012. So we've been around focusing on probate and estate planning for the most part now.
Perfect.
I'm Kristen Collett. I'm a trust officer at Arvest Bank. I have been with Arvest for 15 years, and I've been in the financial services industry for 18 years.
Okay, thanks.
Good morning. Is it on? I'm Crystal Beard. I'm currently with Old Republic Title, a company I started with in 1983. I'm more of the practical person that's on the... You can't hear me back there? There we go. Okay. So yes, I am real life experience, the things we see at the closing table that are unexpected. And I really appreciate the opportunity to be here today. Years ago, I did a lot of first-time homebuyer education, actually for Oklahoma State University. And so I feel like I've come full circle because I'm living the same thing you guys are facing as well.
Well, our group is much more fun than first-time home buyers, I'll tell you. Thank you, Crystal. Okay, so first, because I think it's important that we all start out with the same definition of what we're talking about. We'll just talk a little bit about what is probate, and you can touch on what is estate planning just briefly.
Okay, so everyone owns something, right? So for my 21-year-old, what he owns right now is probably his PS5 and he has a bank account, right? That's his estate. For a lot of us in here, we built up stuff over time. It could be your bank accounts, retirement accounts, your home, all of that. That's your estate. And so you hear the term probating the estate or estate planning. When you do estate planning, you're actually putting a plan in place. You're being proactive about what's going to happen to your stuff when you pass away. 'Cause someone's going to get it, right? And so putting a plan in place, that's called estate planning. Probating your estate is actually going through the legal process to where the court determines who's going to get your stuff and in what proportions. And that may not always be the way that you want your stuff distributed. So that's probating the estate. And I've sat down with people in consults and they're like, what is probate? But that's, I think, hopefully the gist of it.
Perfect. Do you guys have anything to add to that?
I think the only thing I would add that there could be several different types of probate. When you sit down with an estate planning attorney to begin that process, they will go through some questions to figure out what process is going to be the best for you, whether formal, summary. Those are kind of the main two.
Yeah.
I think I'll just add that I don't think any of us want to end up there.
Yeah, how many of you have been involved in a probate for a family member? Okay, was it super fun? Did you love it? No? Yeah, when Curtis gives a big thumb down. It's a little bit of a hassle, and the people that I know that have been through it, the statement that I hear the most, you walk through probate one time for a family member and they say, I am never, like, I need an estate plan. You just have to experience it once to know that you need an estate plan. Okay, great. So we're going to talk about today some myths, if that's okay, and then we'll do a little bit of myth busting and talk about some truths. Some of these we've talked about before, but some of them I think will be new to you. So first is, if I have a will, my family is protected from probate. The will controls everything, and my loved ones can just take it to the title company and sell the property. Is that true? No. All right. So Roberto, can you clarify why a will does not automatically avoid probate?
So there's actually a case, and I'm not sure where the misconception came along that a will avoids probate, right? Everyone says, well, I have a will, we're good. I don't have to do anything else, right? But there's actually a case from 1954 where the court actually says, unless you actually probate a will, it's ineffectual to transfer title to your heirs. So whoever you name in that will is not going to get it unless you go through the court system to determine that.
Okay. Crystal, from a title company perspective, do you often have people come in and try to sell a property from a will? And how long, let's say for instance, somebody, well, answer that first and I have a follow-up.
Unfortunately, yes. We see a contract that may be signed by someone unknown to the chain of title when we pull tax records, which is where we start our title order. If those names don't match under any circumstances, we're going to investigate that a little bit. And when we find out it's different, and we'll ask the realtor, and she usually says, well, this is the person that will administer the will. And that's all they think they have to have. And so we've got a buyer that's under contract that thinks they're closing in sometimes 2 weeks. And then now we're telling him it may be 60, 90, or even longer before we can close. And so in our digital age, a lot of times the contracts are signed digitally. And so you can pretty much sign anyone's name that's typed in there, because it comes to you and you just click on it and it types the name. So we actually see contracts that are supposedly signed by the dead party, but we don't know they're dead because we don't do a public search when we start the order. And sometimes we find out about a week before closing that, oh, well, that's not the person that's selling the property, her daughter's selling it.
Yeah, that was my follow-up question, because if the real estate agent doesn't know and the sellers, because we do run into people who to colleagues, to other real estate agents that don't know that a will doesn't, that's not really something that you learn in real estate school, and so you kind of have to just know that because of life, and because the misconception is so widespread, exactly like you said, I mean, I would assume that it could get really far into the process and a lot of expenses happen before that's found out. So, okay.
We've even had cases where once it's under contract, the buyer's been given possession to the property and done many renovations, like going from a 5-bedroom to a 3-bedroom and adding a bathroom. Well, then you had a stray heir come in, and all they're seeing now is this property that has new granite, new tile, it's been fully renovated kitchen, and that appraised value looks a lot different going into that probate the way it was versus the way it looked at that time. And so there's just problems that are created without that communication early on.
Kristen, if someone if someone only has a will or they haven't even done that yet, what action items are first?
So if you only have a will, I think my first action item would be to review that to see if it's even accurate anymore. So a lot of times when we meet with clients, if they do have a will, most of the time it's 10, 15, 20 years old and they've just, said it and forgot it. And it may not be accurate anymore. The beneficiaries they may have listed may have passed, or some family situations have come up and that's just not who they want to get their assets at the end. Most commonly, though, when we meet with clients, they do not have anything. They've not even thought about estate planning, so that's where we get to come in as trust officers and help them kind of work through the conversation. So we like to meet with people before they meet with an estate planning attorney, because we can get to know them and get to know their family situation, their assets, anything unique to their situation, and we can help them kind of start to make that framework of what their estate plan should look like. And then the priority action item, I would say, would then be to prioritize getting your estate plan completed. Contact that estate planning attorney, work through the process, and get it all the way to the finalized point of where you're signing it, so that they don't just forget. So a lot of times we'll meet with people and then we might follow up a year later and they've done nothing. So prioritize your estate plan, getting it done.
Yeah, important conversations.
And I think it's important to realize that I could put a will together, basically leaving my assets to my 3 kids without, without naming Becky as, leaving anything to her. That's not under the law. She's entitled to at least half, right, statutorily. So what you need to realize is that you often I've seen this before in blended families, which is more common now, obviously, as that has, it's more commonplace to see a blended family. But I think a judge just needs to make sure to say that is the wife protected or not, and are the kids protected? Because if you don't name all the kids in the will, that may become an issue. So that's why that's why a judge wants to see that will before it's found to be valid. I've actually got a contested matter right now here in the state where a will has been presented and just cutting out the kids, leaving it to the girlfriend, if you can imagine. And so we are fighting that it's not actually a valid will. And so there's a lot of issues there. So unless you get it in front of a judge, someone's got to find out to be valid.
Great. Well, if someone finds themselves in need of a probate attorney, so let's say that it's, mom, dad has passed away, and they're looking for a probate attorney to help them through that process, what are some good questions to ask a probate attorney when you're interviewing them?
Probably how often do they go through probate, right? How many probates have they actually done? Have they sold real property through a probate? Because as Crystal said, depending on what you want done, if you want to sell that house quicker, that's going to affect the choices that you have as far as what probate to pursue. But I think that would be my first question, is how often have you done this? And I always tell people, look, you don't want me as a family law attorney, you don't want me as a criminal law attorney, all right? If I'm your family law attorney, you're going to lose the kids in the house, right? If you want me as a criminal law attorney, you're going to end up in jail doing 20 years. So, but if you need probate and estate planning help, I'm here to help there. So how often, and I think that's key, that's critical, because even as, I feel like every year I'm learning even something new within the probate realm.
Perfect. Kristen, what do you recommend people ask before they hire a probate attorney?
I think I would kind of piggyback off what Roberto said on how often they have done that, but you would also kind of want to find out if they have the capacity to take on another probate at this time. So they could be an excellent probate attorney, but maybe their plate is beyond full at that moment. So just kind of ask them questions around kind of the time frame. Another question would be around kind of the cost. You would want to have an idea of what that cost is up front, because each probate is going to cost a little bit different. So they may not be able to give you a very accurate number, but they can give you a ballpark. But just kind of make sure they have the capacity to handle something that right at that time.
I told y'all I was the practical one, and she kind of stole my line, because my first question would be, how much are you going to charge me? But cheapest is not always best. If you're dealing with someone that normally does family law and you go to them and say, oh, it's an uncontested probate, are they thinking, oh, it's going to be like an uncontested divorce? and quote you that fee accordingly. And then when something kind of pops up that's a little difficult and he has to go to the law books or to a different law partner, and then you have added fees. And so from the real estate side, which is my expertise, I would definitely ask if they have handled real estate.
Perfect. Okay, I love it. I don't know that I would have thought to ask that, so that is helpful. All right, next one. I'm sure none of you guys have done this, but I don't need a trust. Printing a transfer on death deed from the internet or adding a family member to my title is a cheap and effective way to avoid probate. All right, do we think that's true? No. Okay. All right, Crystal. How have you seen these shortcuts like transfer on death deeds or adding someone to a deed impact the title process when a property is eventually sold?
Courtesy of Dr. Google, we learn more and more, but it's on the internet, so it's true, is where this one kind of falls really short. The transfer on death deed is kind of a new vehicle in Oklahoma. I'm not going to get into the tax complications, et cetera, because mine is just dealing with getting properties sold. We see people prepare these themselves. They don't get the legal description correctly entered. They vest out without a marital status. Things that leave it open to being contested if someone wanted to step forward. We've seen people put all 8 of their children on a transfer on death deed, and no one thinks about your children being honest with you with their financial goings on. And about half of those children had judgments that exceeded the value of the asset we were closing. So that's a transfer on death deed horror story from that standpoint. We also see people that hold off filing them until the party has passed, and that invalidates the document. So doing things that Mr. Google says, you have to take that with a word of caution.
Can you also touch on POAs, since you talked about the transfer on death deed not being filed until after someone passes away? Have you seen someone try to use a POA after someone has passed away?
Yes, power of attorneys are a great vehicle for temporary vacations where you need someone here. They're great to use in estate planning. But some of them, again, if the person is deceased, the power of attorney is invalid. Certain power of attorneys have information on there that are unaffected by incapacity, but they have to be on a special form. So if a person that gives you a power of attorney is not of sound mind to revoke it, it can also invalidate a power of attorney. So even with a power of attorney, something that sounds like a simple document, from the title side, we definitely ask that you seek legal advice with power of attorneys.
Roberto, what other risks have you seen when people use DIY deeds or adding family members to title as a shortcut?
So I know that I think the county clerk actually may have a deed, right? And I think it's common for people to go down to the county clerk and just get their form. And they put their kids, let's say, on title, and then they pass away. A lot of times we talk about whether or not an asset is owned as joint tenancy or not, right? And I think it's very common to presume that when someone passes away, so if someone takes title as joint tenants, if someone passes away, that title automatically vests in the surviving person, right? But oftentimes those county deeds are not going to have that language in there, and so I've seen that before. The other thing that Crystal has touched upon, yes, on the transfer on death deeds, they do need to be filed before the person passes away, but also you have 9 months after someone passes away to file an affidavit actually accepting that property. And I've seen it to where that person failed to file that affidavit, and then that property actually reverts back to the grantor at that point. It's also common to, let's say, add your girlfriend or your kids to the title. The problem now becomes that they now have a vested interest in that property. So if you decide you want to sell the home, they now have to sign off on all that legal paperwork. And if they chose not to sell the home with you, then you're going to have to go to the courts to force the sale of that home. And I think that that happens probably more frequently than we care to think about.
Yeah, I had an interesting. People don't think about when you add someone to a deed in any way, whether through a transfer on death deed or adding someone to your deed. We had a situation where that person came with some significant debt, that was some tax debt that was then attached to the property and had to be paid off before that property could be sold, and it ate up a huge amount of that person's equity just because they added somebody to the deed. It was not a fun phone call when I saw the title commitment come to me. I didn't enjoy reading that title commitment and then having to call them and say, hey, by the way, are you aware that we're going to get to pay the great state of Oklahoma the tax commission, a substantial amount of the money that you would be getting back. So, okay, Kristen, let's talk about some other, maybe like tax implications that homeowners should be aware of. And are there instances where you do recommend a transfer on death deed?
So just to be clear, I am not a CPA, so I
Yeah.
cannot give tax advice. But from an administrative perspective, some of the things that you would want to consider when adding somebody as a joint owner, you would want to talk to your CPA to make sure there was no gift tax implications, because you could potentially be gifting them, half, 50% ownership of that property. But the biggest tax implication that comes to mind is the potential of capital gains tax. So when you have a real estate property assets, and when you pass away, someone inherits that, they receive what's called a step up in basis. And so what you originally purchased that amount for is then stepped up to that current market value upon your date of death. So that can minimize or cause them to pay little to no capital gains tax. But if we flip that around and you've now added someone as a joint owner on the deed of your house during your lifetime, your original cost basis or purchase value is transferred to them. So you pass away and then they go to sell the property because they're that joint owner. Depending on what your original cost basis is or your original purchase price, they could be paying a significant amount of capital gains tax.
Yeah, yes. So I think to sum it all up, we are all for making sure that you're making cost-effective decisions. No one wants you to make a decision that is not financially smart for you. However, Google doesn't know where you live, and it doesn't know what the most correct document is. It doesn't, and it bears no legal responsibility for doing so, right? So when you hire someone to walk you through that process, you are shifting the liability to that person, and you're paying them not for filling out a document, because that feels like a lot of money for someone to fill out a document. But what you're paying them for is their knowledge and to help you navigate that process and see the red flags before they come and prepare accordingly. That is what that process is for. Myth number 3, it's always best to name a family member as a trustee, and if I don't, all my heirs will still have to agree on every decision. Is that true, guys? No, not always. Right. Okay. So, Kristen, can you walk us through when it makes sense to choose a corporate trustee, and maybe explain what that is? That's one thing that we need to do.
So a corporate trustee is going to be like a trust company or a bank that has trust powers, and where we can be named in your document. So upon your incapacity or passing, instead of naming an individual person, family member, friend, you can name like Arvest Bank Trust Company or somebody equivalent to us. And what that does is allows us to then step in as your successor trustee and handle your estate, handle your affairs, your trust. And it keeps the benefit, I would say, of a corporate trustee is I may not be there one day, but there's always going to be somebody else there. So the trust company itself will be there. So you're always going to have somebody within that company that is there as managing your trust. Where when you name an individual, you're going to need to name backups, multiple backups, because everybody unfortunately dies at some point. And so we want to have that backup so that if that person's not around, you have another person down. It's a good idea to consider a corporate trustee, I would say, based on the size and complexity of your trust, or the nature of your assets or your distribution plan. Maybe you have a trust that you would like to stick around for multiple generations. That would be a good time to consider a corporate trustee, again, because that corporation is going to be there for years to come. Complex family dynamics is a really good reason to consider a corporate trustee. Maybe you have a blended family or you have strained relationships. That corporate trustee is going to be that third party, kind of that unbiased outside person looking in. When you have a beneficiary that may need a special needs trust or a supplemental needs trust, a corporate trustee can be a benefit there because we work with that on a daily basis and we know what kind of distributions to make or not make that could potentially disqualify that beneficiary from government benefits. So some of the values I've kind of talked about, we have professional expertise, education, we're that impartial or unbiased decision making because we are going by the trust document. That is what is kind of the guide to what decisions we are allowed to make. Time, we can save time. We do this full time, so we're working on this every day. If you name an individual, they may have a part-time job, but in our world, this is what we do every day, so we can administer things much more effectively. And one thing we always like to mention is, if you're thinking about naming a family member, think about, do they have the time, the want, the capacity, the knowledge, the skills to handle your trust when you're gone, or estate?
Roberto, can you tell us a little bit about what a trustee does and how is that different from a personal representative? And then, of course, touch on if heirs need to all agree.
Yeah, so one thing that I want to make sure is that we all understand what a trust is, right? I think we've often heard the term put together a trust, but what is it actually? And I think I read online somewhere, and I think this is a good illustration, especially in this group, because we talk about real property quite frequently. But if you can imagine, when you put together a trust, a revocable trust, it's like buying a moving van, all right? And so when Becky and I created our trust, we got a moving van, and we get to be the driver. So wherever we go in life, it's going to go with us, all right? When one of us passes away, the other one, she's going to have to end up driving, right? It's normally me driving, but she'll have to drive the moving van. And then when she passes...
Mostly because I fall asleep when
you do. But when we both pass away, we're then designating somebody to take over that moving van and actually drive it for us. That's where that term successor trustee, who's going to step in and drive that moving van. Our trust is called a trust agreement, and it's the instructions on how we want our assets to be distributed. So our successor trustee is going to read it and say, okay, they want us to take the china and drop it off at such and such house, right? They want us to give the money that's in the bank to this other person, so we're going to drive to that person's house and drop that off. So that's what a trust does, all right? And when we pass away, we're designating who do we trust. That's that term trustee. Who do we trust to actually carry out? Who's going to take the stuff that's in that moving van? Are they actually going to drop it off at people's homes? Or are they going to, run off to a different state? All right, so that's what a trust is. And while we talk about why it's important to choose a successor trustee. So that's the term trustee, is who's going to manage that trust. And during our lifetime, it's us, but it's real critical to make sure that we find somebody when we pass away that's actually going to carry it out. So when it comes to successor trustees, just a little bit about what I look at as an attorney. I actually got to help a family in Norman earlier this year, and they had 3 children. So we sat down and we really wanted to figure out what their goals were. And they said, well, we have 3 kids. They haven't been part of our life for 17 years. I said, okay. When you pass away, what do you want? Do you want them to get that? And they said no. I said, okay, so where do you want it to go? So we named 3 charities that are going to get it when they both pass away. Their total estate is over $3 million. So if you can imagine, these 3 kids are missing out on at least $1 million each when they pass away. I recently heard that the wife did pass away, all right, and so now it's just the husband. For us, because they didn't have anybody, when we sat down and said, okay, who do you trust? I said, well, we go to church, but they don't really know us very well. I said, okay. Is there anyone that you can think of? I said, no. I said, well, have you thought about a corporate trustee? And this is where it's been really great getting to know the other education partners, because I said, I think I've got somebody for you. And so we actually named Arvis in their document to take over when they pass away. Same thing on the POAs, right? They didn't have any family members or people that they wanted to serve as their guardians if something were to happen to them, if they were incapacitated. And so we were able to name Purview in those documents, right? People that we trust. So having that honest discussion on what that plan looks like when they pass away is real crucial, and especially when you're trying to pick successor trustees. Especially with a $3 million estate, you want somebody that's able to handle that kind of money. A personal representative, on the other hand, is somebody that you name a will that is supposed to, who's in charge of, when you pass away, actually going to the court and filing that will. Well, you need to realize in Oklahoma, we do not have a statute of limitations on a will. I actually probated a couple years ago a will from the mid-1960s, right? And it was a mineral interest, but a will's valid, unlike in other states where after a certain period of time they become invalid. But a personal representative is the person that's actually going to represent the estate in the courts, right? And whether or not, if they all have to agree, right? Your trust is going to set that out. Generally, they're not going to require that in a trust agreement, but in a probate, whether or not the family agrees on every decision is going to determine how long that probate is going to be open, right? And if they don't agree, I can only guess as to the cost that's going to be associated with that probate. And just a quick example, I had one house in Moore. Mom passed away. $170,000 is what the house was worth. And mom passed away. Daughter was living with her. She had a felony. She had drug problems. We represented the brother. Fast forward, it took us almost a year to get the probate done. They fought tooth and nail. We were able to force to sell the home through the probate. Total attorney's fees in that probate were $45,000. The house sold for $160,000, so that's all that went through the probate. $45,000 went to attorneys. The rest was split between the brother and sister. So if they don't agree, that's potentially what can happen.
The more arguing, the more hours, the more dollars. Yeah. Yeah. Crystal, when a trustee is involved in a sale, particularly a corporate trustee, how does that streamline or complicate the title and closing process compared to when multiple heirs are involved?
I'm going to back up real quick to something that Kristen was talking about and how the value of the corporate trust comes into play. One thing that wasn't mentioned was just the loss of someone. You're asking someone to take over running assets and you're still grieving. And then the family members come out of the woodwork and you're still grieving and they're grieving and you can't say no. And so then you start, I don't know, I could go on and on about that, but I do see that it needs to be a strong person that's not easily persuaded if you're going to appoint someone that is not a corporate trustee. We see, even when two people in a successor trustee situation where they've appointed two of their children, they still fight. It still ends up in legal fees. It still ends up in hard feelings. In the 40-something years that I've been closing, I've only had to call the police one time, and it was over a salad bowl that an aunt had, and they had given aunt a third so that hopefully the grandchildren would have something. That was her only purpose, was to protect the grandchildren's interest. But yes, they physically got in a fight over a salad bowl and who took the salad bowl. So there's just high emotions sometimes with this. It's super, super easy for us when a corporate trustee is involved because they go through this, their emotional list, mainly, I mean, you can be compassionate and take the emotion out of the equation. From a title standpoint, the biggest problem with us is finding trust agreements. How many of you have sold a property through a trust?
Anybody?
A few? Okay.
Shannon in the back.
Okay. From an escrow closer, the nightmare we have is calling and saying, Ms. Smith, the Smith Trust owns this property and we need a trust memorandum to show who has the authority. And them saying, we can't find any trust papers. The second nightmare is them bringing me a 3-ring binder or 5 and saying, here. So that also matters when you're having an attorney prepare those papers. Again, I'm real estate inclined, so I really like someone that's real estate thinking. And so papers get lost. Roberta, how do you feel about memorandums being filed at public record before they're actually needed to be filed?
I don't generally recommend that, only because you can change your mind on who your trustees are and your successor trustees, right? So unless it's really needed for that actual transaction, I would probably hold off, right? And I think that that's one key thing that you talked about is I don't know where it's at, right? And there's no requirement to file a trust, right? Probate is very public. Whereas a trust, and that's what I tell people, that's private, right? And you can change your mind. You want to cut out the kids, they won't know, and that's huge. But probate's a very public process where a trust is not. And I'm a big fan of doing memorandums of trust for transactions, and I'm a big believer in that.
Okay. Next up, once I create a trust, everything is automatically handled. I don't need to think about it again. Is that true? No. Nope. All right. Okay, so Roberto, what does it mean to fund a trust, and why is that step so crucial to making sure that the trust actually works as intended?
The funding a trust, I think the easiest way I can explain, let's go back to that moving van analogy that I was using, right? I can buy the moving van, but unless I physically put my assets into the moving van, right, that moving van is not actually going to move it around. So funding a trust is actually where it's the process of retitling your assets, right? So when we work with families, we'll create the deed that actually transfers the home into the trust. We talk about updating beneficiaries on life insurance policies, on retirement accounts. We guide our clients through that process. Bank accounts, right, have to be retitled in the name of the trust. So when Becky and I created a trust, we had to go down to the bank and sign new signature cards at that point. Now when I log online, it actually says the Roberto and Becky Trust. But until you actually proactively take that step to put it into that moving van, it's just going to sit outside the moving van. And if you pass away, those assets that are not in the trust are still going to have to go through probate at that point.
Yeah. And Crystal, this is one that we did together, but what are some issues that you've run into when a trust has not been properly funded, especially with real estate? And the transaction that we did together that comes to mind is the one where half of the half of the property had to be probated. So
A lot of times when somebody's owned an asset, real estate specifically, for a while, they'll deed back and forth, different parts at different times where they've acquired this 40 acres at this time or this lot at this time, and some of them are after the trust has been prepared and they may not be put in the trust. And so when we do title work on all of those different tracts together, we find ownership partly in the trust and partly in individuals. So there was still a probate required. Attorneys can only put in the moving van what they know needs to go in the moving van. And we have seen that time and time and time again where nobody did deeds to put real estate into the trust. And so they'll sign contracts as trustees, and it's never been put in the name of the trust. We also see just typographical errors, and the small things matter when it comes to those documents. You don't want to try to fix something after someone has passed. Quick story.
of course, yeah.
This is a case that happened, I believe, a year ago in December. It was when it went to the state Supreme Court. It was a property in McLean County. And this gentleman owned a little over 100 acres and went to deed his son about 15 acres, kind of in the middle. And son goes on to build a $750,000 house on this 15 acres. And about a year and a half after that, he gets a foreclosure notice, only he didn't have a mortgage. He built his property out of his pocket, and so there was no liens on this 15 acres. So he thought, Dad had owned all of this 100-ish acres, bought it at different times. Some of it was in a trust, some of it wasn't. Well, when he deeded to his son, he deeded to his son individually, and he owned that particular tract as a trust. Well, when he became in financial trouble with his business, of course, the bank forecloses on the assets, and because that property was not conveyed accurately, he lost his house. And he did take it all the way to the Supreme Court, saying it was a Scrivener's error, which is, in our language, is just a typo, for a better term, to prove that it was an error, but he was not successful. He did lose his place. So when we're talking about estate planning and all of that, you know, just because Bill's brother is an attorney and you trust Bill, please vet all of your financial decision making. Be sure you vet those partners.
Well, and the one that we did together was really interesting. It was also kind of a clerical error. I think that the attorney probably should have caught it, but the way that the property was deeded, they were deeded as tenants in common instead of joint tenants. So when husband passed away, the wife went to sell the property, and it had been put into the trust, but because of the way that the deed read, half of the property had to be probated, which is very interesting because half of the property was in the trust and half of it was not. So just making sure that, you know, things have been deeded correctly and things like that, which leads me to my question for Kristen. For someone who's unsure of what property that they own and what needs to be put into that trust, what resources are available to them to look and see what they actually own?
A good starting point is going to be that county assessor's website. Whatever county you're in, you think you have property in, look there. There's also a resource that we use called okcountyrecords.com, and it is another public resource out there that you're able to pull up any deeds or anything. For the majority of the counties in Oklahoma, I don't think it has all of them, but the ones that are missing, you can typically go straight to their county assessor website. And when we have a new client, that's typically what we do to kind of help confirm the different assets and the ownership of the assets. Another thing that we always suggest that people look at is look at the Oklahoma State Unclaimed Property website. So oftentimes people may have inherited maybe oil and gas royalties or mineral rights and they don't know. But if we find checks that, you know, they have funds out there that need to be claimed on the unclaimed property website. So that's always a good thing to kind of keep in mind as well.
How often should people review those assets?
So reviewing your assets, I think that would go along with your estate plan. For the most part, we recommend that you review your estate plan every 3 to 5 years or at any major life events, just to make sure that everything is still in order. With your assets, you want to make sure that you're kind of keeping an inventory of those assets that you can update as you go. So if you've sold an asset, you can remove it pretty easy. If you've acquired a new asset, you can throw that on your inventory, which I think is going to lead into Becky's next question.
Yeah, how does it prevent assets from slipping through the cracks if you do that?
So we always recommend an inventory. When you're doing your estate plan, you're going to be discussing with the estate planning attorney, like Roberto mentioned, all of your assets, and they're going to help you come up with that list for your funding, you know, how to get the title in those assets. And that's a good beginner's point to creating that inventory. We also offer a service to our clients during that same process that we're creating a financial plan for them that we call Blueprint. And through that process, we also gather information on their assets, their liabilities, and that in turn kind of help build that inventory. That way you have an inventory built that's easier to edit as things come up when you sell or you buy things. But keeping that updated and keeping it with your estate planning documents, whether that be a binder in the safe deposit box, wherever you keep those, having that inventory is going to give your personal representative or your successor trustee the best starting point on your assets. And if you keep it up to date, it'll help things from slipping through the cracks. However, there's always stuff out there. If something does slip through the cracks, that's where that will's going to come into place.
I love that. And I think also just being mindful, right? Being in a good practice of getting those things written down and practicing that on a recurring basis is going to help you a lot, I think. Yeah.
So Kristen mentioned something, that's where that will comes in place. That's what we call a pour-over will. A lot of times we're saying, hey, let's create a trust. We don't want to rely on a will. But when I sit down with people and we're like, and we're going to do a pour-over will, and they're like, but Roberto, you just said we don't want to do a will. All right, that pour-over will is kind of like a safety net. We don't want to have to use it, but it's there in the event that you do miss something. All right, oftentimes it may be an asset that's inherited from family, or let's say you start a new job and you have this new retirement account that you forgot to put the trust as the beneficiary. That pour-over will is there to catch anything, to make sure that it gets into that moving van after you do pass away. And where is this critical, right? That family that I helped in Norman, that we're disinheriting the kids, that's their intent, for them not to get anything. Well, if they failed to get something into the trust, we're going to make sure that those assets do make it into the trust to make sure that their intent's carried out, which is not to provide for their kids.
And just for clarity, you said pour over.
Pour over will.
Pour over will. Yes, if that's a term you haven't heard before, that might be something that you could look into or ask your attorney about. Myth number 5, probate is always a nightmare, long, stressful, and expensive. It's fine to let the house sit until we are ready to deal with it. Is that true? That always? No. Okay, so Roberto, is that true? What can be done? And you touched on this before. The more hours involved, the more expensive it becomes. But talk about some of the different probates that might be a little bit less stressful. This is speaking to people who have not done their estate planning and now they're dealing with the estate from a family member who has passed away.
Right. So generally in Oklahoma, we do a regular probate and what's called a summary probate, which is a shorter probate. When I sit down with people, one of the things that I want to find out is there a house, right? And we worked on a transaction a couple years ago where mom owned a home that did not get properly funded into the trust, and we were having to sell it. It was $100,000, not in a good area of town, right? But because it was $100,000, we could do the shorter probate, or we could sell it through a regular probate. In that case, it was important for the client to sell that house as soon as possible. So what we ended up doing is doing a regular probate and then selling it through. We were able to sell that home in half the time. So providing options to our clients, even though it was a little more expensive for her, getting it off her plate and making sure that that home didn't go into disarray was important to her. So that's where sitting down with and really trying to figure out what your goals are, or the client's goals are, important.
Yeah, I think that goes back to working with an attorney who knows what the options are, and I make Shannon Steiger, who we all know and love, and she and I work closely together, and I say something frequently that she hates, and I love it that she hates it. It makes me so happy, but I'm gonna say it. I am going to say it. Because we do such a large amount of business, it is very hard to stump me. Now, I have changed it because I used to say you can't stump me, but Shannon made me say it's very hard to stump me. I will tell you, no one stumped me yet. But I will say, and so I invite the challenge. But what I will say, when you're working with an attorney who does probate regularly, you're getting the same experience. It is someone who has seen some things, they've seen some interesting things, and they know what your options are. So that's what you're talking about when you sit down and talk to somebody. And if you hadn't done very many probates, you may believe that, hey, it just fits in this one probate bucket and this is the option. But knowing the intricacies, I think, is important, yes?
It is important, and I realize that there are some attorneys that don't really know how to do a summary administration probate, right? So they don't feel comfortable, and they don't offer that as a choice, where there are certain times where it is the best choice.
Yeah, great.
Can I?
Yeah, it's your turn.
Will
Let's
you
do-
read the second half of that question again? Or the myth?
Well, I don't remember, and I can't read it because I'm old. Okay. It's fine to let the house sit until we're ready to deal with it.
When you have assets sitting out there, and for a lot of us, they're not 100% mortgaged assets. If we're fortunate enough, they're free and clear assets. That is a big target for fraud right now in Oklahoma. Oklahoma's not been a relatively big target for fraud in real estate because it has to be monetarily worth it for the fraudsters to take that risk. And if they're going to try to commit it once, do they want to commit it here on a $350,000 house or in New York where it's $35 million? It's going to be the same crime either way, right? Same fine, punishment. So this is what we're seeing on the title side, is properties that have been vested in an individual or family, husband and wife, for 25 years, and the last 10 to 15 years it may have been put in a trust. Excuse me. And then all of a sudden we see a quitclaim deed that's within 6 months old, or a warranty deed that'll have doc stamps on it and everything, looking like a very legitimate sale. And then we get a contract from those people that bought that property 6 months ago that's not a valid deed. It's totally forged. And they try to sell the property. And there's times they've successfully done that in Oklahoma. Of course, it's fraud. The buyer got their protection from title insurance, but you, the homeowner, aren't protected. Your title insurance only covers past items, is what I'm saying. But this is what I want you to be mindful of. If you've owned property for a while in Oklahoma County, how many are Oklahoma County residents that own real estate? You can register with our county clerk, and they will send you an email anytime anything's been filed on your legal description. It's not guaranteed, it's not full safe, but it's better than what we currently have. We had 5 that just ran across our escrow office, not our company, and we have 8 offices around the metro, but we had 5 within the last year just at our office. So while we were on that, I really wanted to touch, don't just think because of the assets out there, it's in a trust or it's properly vested, that somebody's not going to try to take it. And they can't legally take it, but you are still going to have to fight for it. The Oklahoma County Clerk,
I have the contact information for it. I can tape it on my door right outside here. You can stop by and copy down the information.
wonderful,
on the way out.
wonderful. I know some
I
other
love Tara so much.
I know there's some other clerks that offer that same service, but I just felt that that was a perfect time because we do think that stuff sitting out there is just perfectly fine. And we're seeing in this day and age, unfortunately, that that's not always the case. It's a very public asset because it's real estate and we can search those. And then all I have to do is go to the clerk's office and see that it's been in the same family for a long time. They're probably not moving, you know. They're not taking out mortgages frequently where title's being checked.
Houses need people in them for lots of reasons. Kristen, from a financial planning perspective, what are some hidden costs of letting a property sit too long?
I don't know that they're necessarily hidden, but even if the property is vacant, you still are required to pay those property taxes. Say if you don't pay them, maybe when you go to sell it, they'll check the tax rolls to make sure they're paid, and maybe there's a couple years worth of taxes due all at the sale of that house. Ideally, you're still carrying insurance on that vacant property. You never know. We live in Oklahoma, so you never know what may happen in that interim. You also have the upkeep and the maintenance of a property. When we are settling out a trust or an estate and we have vacant property, it's very important for us to make it sure that we're keeping up on the maintenance and making that house appear lived in, if possible. Vacant houses, like they mentioned, are a very big target. If somebody drives by frequently and they recognize that there's nobody there, it just becomes that target for vandalism, fraud, which then could cost you more repairs down the road just because something has happened, or additional like insurance claims. And then another thing is if it sits too long, the property could be stigmatized as a vacant property. So then when you do go to sell that property, maybe somebody's interested in purchasing it, but they're not going to pay, the asking price because, hey, that's been vacant for a year or two. So it may be harder to get the value of the home out of that.
If I may, to go back to the actual myth, right? So we're talking about it's not always a nightmare, right? When family gets along, when the kids get along, it can be a pretty straightforward process, right? So the short probate, just to give you some context, a short probate can usually be done within about 2 months from when we file the petition. But it still usually costs about $4,000, and that's what the retainer that we take initially. So it's about $4,000 to do the short probate if it's uncontested. If a regular administration is uncontested, you're still going to find that it runs around $5,000, but it usually takes about 6 months to get that one done. But we do have our probate nightmares, right? Where I had one a couple of years ago that I think you were trying to help potentially look at a property. She died with no lineal heirs. The court determined that there were 65 heirs in that probate. That meant that everything that went through the probate was split 65 ways, right? That one was contested because the decedent.
It's class change, but you have to stay.
Yep. The decedent in that case, so she had 65 heirs, right? But she was befriended by a friend's daughter, right? And that friend's daughter actually got a fake POA, proceeded to sell some of the property. So the estate had to fight to try to get that property back into the probate. When all was said and done in that case, I believe that attorney's fees were somewhere in the range of $85,000 to $90,000. Right, so that you do have your probate nightmares, but it does not always have to be that way if people do get along.
And just to touch on, and I don't have this on here, so this is a price question. But when a property is going through probate, can you go ahead and get rid of the personal items that are in the home?
You cannot, right? So that asset is still owned by that person. Right, and that's something, unless it's perishable, right, food, you can throw that out. For the most part, those assets are frozen until the court determines where it's going to go, right? So you can't get rid of the china and all the little knickknacks that have built up over time.
Okay.
Salad bowl.
The salad bowl. I have never in my life owned a salad bowl worth fighting over, but I mean, I would like to see a picture of it. Crystal, going back to doing your research mindset, how have you seen people get in their own way and make the process longer and harder than it needs to be from a standpoint of just putting it off and things like that?
I mean, I've shared some of them. You talked about unpaid property taxes. That is also where some of these fraudsters will get their first little inkling that a property's setting or being unmanaged, even if you just missed paying 1 year or your second half or whatever. That when those public notices go out that properties are going for tax sale, that they're looking at that. We had one case where the lady in Texas didn't even know her father owned property here. It was only 3 lots. I mean, they were, even in today's market, worth only $4,000 or $5,000 a piece. It was not prime real estate. But until someone tried to sell property here and found out that the gentleman that owned it was deceased, they didn't. The power not being on, the pipes bursting and stuff with real estate setting. And again, horror stories, your neighbors that you know and love and will have your best interest at heart, but that cousin Jim Bob, that's over there having Thanksgiving turkey and y'all are talking about, oh yeah, Miss Mary passed and that house has just been setting. Well, just because you trust the neighbor doesn't mean you trust the relatives of the neighbor. So you just really don't want any of those assets that can become targeted for fraud right now.
Is a personal representative in the issue of a vacant house, a personal representative or a trustee have an obligation to maintain that asset?
Roberto?
So
Well-
the question was, in the case of a vacant home, does a personal representative or trustee have any obligations, right? And definitely within the courts, right? The personal representative is supposed to act in the best interest of the estate. So if they fail to take action in pursuing that probate, right, and they just let it sit there for a couple of years and now it's in disarray, that I think an argument can be made to the judge that yes, in that case, the house was worth X, but now it's worth less, right? And that maybe the PR should be held accountable for that. And I think that that's an argument that can maybe be made before the judge.
All right, myth 6. If a property is in probate, nothing can be done until the process is over and there's no way to speed it up. So this is kind of a continuation of, but I did want to touch on what are some proactive things that we can do when we find ourselves in a probate situation. So can anything be done with the property before a probate is finalized, Roberto?
Yes, and that goes back to what is the ultimate goal, right? We had a property that Becky and I actually got to work on, I believe it was 2020. Her client reached out to me, Dad passed away, we needed to probate the home, right? And I gave him his options, he could do a regular one, he can do a short one. He decided he wanted to go with the short one, and so when I did that, I was able to give him a final hearing date, and I said, Becky, after this date, you'll be able to sell that property. So what Becky did during that time, she put it on the market, got it under contract, and we were able to do a normal closing up to the point that we were ready to sign the deed over. And so I got the final order in the middle of August, and a week later, they closed on the property. So I think that you can, depending on your situation, speed things up. The other thing, going back to that house that you had, right, she wanted to sell it as quick as possible. So we decided to go with a regular probate so that we could
Not
get-
me, the client.
The client decided, yes, sorry, that she wanted to sell it as quickly as possible, so that's the route we took that time.
Yeah. Crystal, how do title companies work with probate courts or attorneys to keep things moving during the process?
A title company's attorney or our general counsel are not going to represent anybody in an estate situation. But from a title standpoint, we are going to make sure the attorney's documents that are filed effectively and legally are allowing the transfer of that real estate. We're in communication with them pretty early on in the transaction to find out exactly which version they're going, so that we can let lenders and buyers know if we're probably going to have to be extended. And that does happen a lot. And so it's like everything else, communication. We try to communicate with everybody throughout the transaction.
Yeah, great. Kristen, what role can proactive planning play in expediting the process?
So proactive planning is going to help just the much smoother transition of those assets upon death. You're not going to have to go through any probate if they're titled funded properly into like a trust. You wouldn't be going through any sort of probate. You wouldn't have to be at the mercy of the courts, getting that docket date. But really, I think the biggest part about proactive planning is proactive planning can help plan for incapacity. So most of us are going to become incapacitated at some point in our lifetime before we pass. So during your estate planning process, your attorney is going to also prepare powers of attorney, which have been touched on a little bit, and your successor trustee, if you created a trust, would be listed. And those are the people that would be able to have access to your funds, your property, to be able to help manage that during your incapacity while you were still alive. So I would say that that is one of the biggest benefits of an estate plan is not only are you preparing for what happens after you're gone, you're preparing for things of who's going to help me handle my affairs when I'm incapacitated.
Perfect. Well, I want to know whose responsibility is it to know the implications of not doing your estate planning and knowing that a probate is coming for your family if you don't do your estate planning? Whose responsibility is it to know that?
I think we all bear the responsibility, right? And I think that it's just one of the things that I really try to pride myself on is I give the information and allow people to make that choice, right? I want everyone, and I think that that's an underlying theme here in the Senior Living Truth series is that we want to give you the information so that everyone can be informed and choose what they want to do. Do they want to go with just a transfer on death deed, or do they want to plan out a little more in the trust? And I think that there's pros and cons to both, but I think that giving everyone a choice, but I think it starts with educating everybody.
Yeah, so I didn't know is not an acceptable answer.
No.
All right.
Real estate is definitely in ignorance is bliss is not
Not
the case.
Not the
No,
case. Yeah.
Definitely not.
Yeah. Okay, so before we open it up to Q&A, what have we left off? This is your opportunity to make sure that you say what needs to be said. So Crystal, I'll start with you.
Since we're kind of focusing on probates and trust briefly, I'm just going to talk about how you own your real estate. Make sure you're entitled as joint tenants if you want to be. If you're not wanting to be joint tenants, make sure you're not joint tenants. Quick, joint tenancy means rights of survivorship where you would not have to probate the estate. I thought I better explain that.
Yeah.
Tenants in common might be me and my friend are going to buy a house to rehab, and if something happens to me during that rehab, I want my 50% to go to my family. So my estate would have to be probated for her to sell that property. But in joint tenancy with me and my husband, if something happened to either one, it would automatically come over. And that's what we see a lot of times in Oklahoma. At the closing table, the seller signs the deed. The buyer doesn't even half the time see it until it's already recorded. So if you bought from a company or a trust, or just look at your deeds and make sure title is vested correctly for what reason you want it vested.
And just to clarify, when you say in a joint tenancy, it doesn't have to be probated, what you're meaning is if one person passes away, it automatically goes to the next person. But when that person passes away, then it would need to be probated.
That
if
is
it's not
correct.
held in a trust. Yes.
Yes, it's just
Okay.
the first person that dies would prevent, or if there's 5 of you in title, until all of them are passed, is when the
Perfect.
probate would.
Thank you. All right, Kristen. And I need a trophy for not messing up Crystal and Kristen.
You have done well.
Very well, very well.
Thank you.
Still have a few minutes left, though.
Oh, that's true.
No. I would just say communication and start reviewing that process. I mean, everybody needs some sort of an estate plan. And, you know, some may be a little bit more complex than others, but just don't be afraid to start the process. The hard conversations, nobody likes to think about it or talk about it, but you'll have a lot more peace and be able to sleep a lot better at night knowing that you have determined what's going to happen to your affairs after you're gone.
Roberto?
I think that cheapest is not always best, right? Trying to save $1 today may cost your family a lot more down the road. And, you know, I always tell people, because I've had some people that say, well, I don't really care, I'll let the kids handle it after I pass away, right? And you don't know how someone's going to react to your passing or to a loved one's passing until they've actually passed away. And I've had many consults where 2 of the 3 siblings are there, and they just tell me, I can't believe that our 3rd sibling is acting that way, right? And so what could have been a relatively straightforward probate is now going to be contested, right? So sit down, you know, at the end of the day and figure out, when I pass away, what does that picture look like on how my assets are going to be distributed? And if you're good with that, you know, then great. If you're worried or concerned, then I think you possibly should look at least talk to an attorney about doing an estate plan.
Perfect. Okay. So we're going to open it up to Q&A. This is how this is going to work. We're going to give 2 of these mics over, and then you guys will need to share a mic to answer. Okay. Also, My three friends up here are going to stay for a little while after if you have maybe a more private or a question that's sensitive and you want to ask to them. And then my only third note might be that if it's a comment and not a question, that would be something that we would want to talk about afterwards. So let's keep this to questions only. Good? Corey, you've got one?
You haven't said anything about abstracts. Do abstracts come into this at all?
Crystal, I'll let you take that. You want to pass the, yep.
So abstracting laws have changed in Oklahoma. And when I say recently, I mean within the last decade, because I've been doing this for so long. Abstracts are just the history of that land. A history of what's filed publicly of record that someone can review for title defects, etc. We are one of only a couple of abstract states left in Oklahoma, but an abstract is, worst case scenario, if an abstract can't be found and it's a state asset that's going through, the abstract is just then recreated. So it's not, most of them are digital now anyway, and so there's not even a paper form out there of them. Does that answer your question? No, the abstracting certificates in Oklahoma for title insurance purposes are only good for 180 days. Now, if you had an asset that you wanted to make sure was vested a certain way, you would definitely want to talk to the attorney and see if he wants to have an abstract updated so that he can determine that, or whether he just wants to have a title report or check the records for vesting himself. So it could be helpful to have, but I don't see any reason in actually bringing it to date unless an asset is being sold.
JD?
I have two real quick questions. Number one, on inventory. On the back of my trust, I've got sheets for adding inventory information in there. Roberto, am I putting that item in that inventory or taking it out, is that now considered part of the trust?
No, just by listing it on that list does not actually put it into the moving van, right? So you've got to go through that process of retitling it. One example that I didn't give earlier, but a mom created her trust and put everything into the trust. When she passed away, it was discovered that she never updated the beneficiary on her life insurance policy. It had named her daughter, all right? Because it named her daughter, when she passed away, the life insurance said, okay, this $75,000 is going to go to daughter, but what they discovered there was the daughter actually her deceased mom. And at that point, we had to do a probate for that $75,000 life insurance policy. So just listing it on there is not good enough. You actually have to go through the process of retitling, all right? So actually physically moving it into the moving van, if that helps.
Okay, thank you. The second question is a quick one. You made the reference to file a trust. I'm not sure I understand what you meant when you said that. You have to file a trust.
So a lot of people think that you create this trust, now you have to go file it with the county clerk. You do not, right? That is confidential. That's for you to, it's private. When you file something with the county clerk, it's now public record, and anybody can go online and actually look at those documents. So you don't want to run down. If anyone says, have you filed your trust with the county clerk, just let them know that that's not a requirement for you to go through. And talking about abstracts and title reports, it reminded me, before I switched over to probate and estate planning, I was an oil and gas title attorney, and I did many title opinions. And through that process, I don't know how many times I would see people owning a mineral interest who now have passed away, and the probate was never done. And mineral interests in Oklahoma are considered real property, and they are required to go through probate. So if you own mineral interests, you probably need to go do something with that, because what's happened over time is that whereas somebody back near statehood may have owned 5 acres, as you can imagine, as life happens and someone passes away, that mineral interest is going to continue to get fractionalized. And I don't know how many title opinions I've done in my history where I actually had to go out to 6 or 7 decimals before I can even get a 1, right? So someone owned 0.0001 of a net mineral acre. That mineral interest may only be worth $50, $100. It still has to go through that probate process. So oftentimes family members just say, well, I'm not going to do it because I've got to spend $4,000 to go do that. And that's unfortunate at this point, but that's the state of title on the mineral interest side of things. So if you do own mineral interest, be sure to do something with it.
Okay, my question deals with what you said earlier about moving your financial assets into the trust. Why would you do that if you can leave them beneficiaries to the people you were going to put in the trust anyway as the trustees?
Right, so when we sit down, we do want, the situation's different so the question is why would we want to move retirement accounts, let's say, into the trust when you can just name them as a beneficiary? And yes, when we sit down with clients, retirement accounts, we do not move into the trust during your lifetime. Now, if you're an individual, we will want to name the trust as a beneficiary. If you're married, then it's a whole different story. We're going to advise to name your spouse first and then the trust as the backup, right? If you move a retirement account into a trust during your lifetime, there's going to be tax consequences for that. And we don't want to put you in that place, right? So depending on the type of asset, we like to discuss what the options are. When it comes to life insurance, right? You can't put a life insurance policy into the trust, but we definitely want to name the trust as the beneficiary. So depending on the asset, some assets will go into the trust during the lifetime, and some assets will go into the trust after you pass away.
Okay, we're running a little bit tight on time, so we're gonna do one more, but please hang out afterwards and ask your questions. They're so important. Yep.
Does the successor trustee, are they entitled to a percentage of the estate for all their time and effort?
So is the successor trustee allowed to be paid? That is a discussion that I want to have with the clients. If the trust says that they're not going to get paid at all, and if it's a family member, then they're not going to get paid. But if it does allow for them to get compensated, then we can put language like that. Now, if you have a corporate trustee, for example, then they will have their own fee schedule, right? There's pros and cons. If you can name your kids, and that will cost less, but if they end up fighting, that may actually dwindle the estate even more. Whereas if you name a corporate trustee, it could actually save the trust and the estate money by doing that. So just know that there's pros and cons to either way.
Perfect. Well, in an effort to keep us on time, we'll go ahead and release our panelists back to their seats. And Shannon, if you want to go ahead and come on up. And the education partners can make their way back to their tables if they have not already. They will be staying after, so I know. But they will be staying after, so please come and ask them questions at that